What if a political and legal system set up, 1400 years ago, actually dealt with stuff that feels super modern?
Uh-huh. Like what specifically?
Well, things like governance, when everything's high pressure, the absolute need for independent oversight in the Constitution, and the ethical duties of
Right,
leaders.
the big questions we're still wrestling with.
Exactly. And imagine if those rulings, which were meticulously documented way back then, could offer us a kind of moral compass, a structural guide for today's world. With AI, globalization speeding up, all the political mess.
That is precisely the core idea of the huge study we're tackling today. It's quite something.
It really is. Welcome, everyone, to the deep dive. This is where we take these massive, complex, scholarly works, sometimes spanning many volumes, and we boil them down.
Yeah, we try to distill that core knowledge you need.
So you can be informed, make those connections between, history and what's happening right now.
And today, we're really going on quite a journey deep into the foundations of jurisprudence.
So tell us about the source material. It sounds immense.
Oh, it is. This deep dive is based on an incredibly detailed scholarly work, The Foundations of Islamic Jurisprudence, Prophetic and Caliphal Legal Precedents.
Okay.
And just to give you a sense of the sheer scale,
Oh.
we're talking 10 volumes,
Mm-hmm.
and those are broken down into 50 subvolumes.
Wow.
50. It involved painstaking research, really digging into 120 specific foundational constitutional cases. And these were all decided by Prophet Muhammad, peace be upon him.
Right.
And these aren't just like historical stories or anecdotes.
No.
They're presented as actual case law, precedents that define the architecture of how a state should function.
And constitutional places, let's be clear what that means in this context. We're talking decisions that set the ground rules for power.
Exactly. How power is distributed, civil rights, economic policies, the actual mechanisms for justice.
So applied frameworks, not just theory.
Applied political and legal frameworks, yes.
So our mission for you, the listener, today is to lay out this blueprint, this legacy built on 120 cases. Because, let's face it, you're navigating a world that's constantly changing.
It really is.
You've got AI making decisions that impact real lives, massive globalization demanding new ethics, political instability. It's a lot.
It is. And connecting that back, the argument in this source material is that these historical rulings offer a kind of ethical blueprint for right now.
How so?
Well, they detail how to build fair societies, how to set up strong economic safety nets, how to ensure institutions are actually accountable.
Which are all vital things for managing the complexity we see today.
Absolutely. The source argues this system gives us tangible, applied precedents, especially, it says, for tackling the sort of moral and systemic confusion that's cropping up with AI and just the sheer speed of change.
Unexpected wisdom, then.
Unexpected wisdom from 1400 years ago, but potentially very applicable today. That's the premise.
Okay, this is fascinating. Let's unpack this legacy. It's huge, 120 cases. How are we going to approach it? How is it organized?
Right, so the source itself structures it logically. To help visualize it, the 120 cases fall into 5 main thematic categories. Think of it as a roadmap.
Okay, give us the roadmap.
So, Part 1 kicks things off with the initial constitutional foundations, the building blocks.
Got it.
Part 2 then looks at how those foundations held up under pressure, emergency powers, and crisis management.
Stress testing the system.
Exactly. Part 3 zooms in on the individual experience, legal aid, ethics, and victim rights, the human side of law.
Important.
Then Part 4 shifts to something critical for long-term survival, knowledge and institutional memory. How do you make sure the law lasts?
Right. Preserving the knowledge.
And finally, Part 5 provides the appendices and the analytical framework. This is where the authors synthesize everything, pull out the core principles, and discuss the relevance.
Okay, that sounds like a clear path. Let's start at the beginning then. Part 1. All right, Part 1, constitutional foundations, cases 1 to 24. Let's paint the picture. Where and when are we?
We are in Medina. The year is 622 CE. You have to imagine the scene. It's complex.
How so?
Well, you've got the Muhajirun. These are the recent migrants who came with the Prophet from Makkah. They're newcomers.
Okay.
Then you have the established local tribes, the Ansar, the helpers. They have their own ways, their own history in Medina.
Yeah, right. Existing social structures.
And on top of that, significant minority groups. Specifically, several influential Jewish tribes, each with their own customs, their own laws, their own loyalties.
So a real melting pot. Potentially volatile.
Absolutely. No single unified political authority. Just a web of tribal agreements and potential friction points. Chaos, basically.
And into that environment, the prophet had to establish a state.
Precisely. And not just any state. but one built on a foundational document, something that could actually supersede those ancient tribal loyalties.
Which brings us to case one.
It does. The first, and arguably the most critical ruling detailed in the source material, is Case 1, the Constitution of Medina.
Okay.
And the authors, as I mentioned, make that strong argument. This is effectively the first detailed written constitution in human history.
That's a huge claim. What made it constitutional? What did it do?
It wasn't just a truce, an agreement to stop fighting for a bit.
Right.
It was a legally binding contract. It actually created a single political community, an ummah.
And who was in this ummah? Just the Muslims?
No, and that's key. It explicitly united the Muslims, both the migrants and the helpers, and the Jewish tribes, plus other allied tribal groups. Citizenship was based on living in Medina, part of this new political entity, not just on religion or tribe.
Okay, that's significant. What guarantees did it offer?
Several crucial ones for building a state. First, unqualified freedom of religion for all the groups named in the document.
Unqualified, right?
That's what the text details. Second, and maybe most importantly for stability,
Yeah.
collective defense.
Meaning?
It legally established that an attack on any group covered by the Constitution was an attack on the entire political body.
Ah, so it's centralized security. One for all for one, legally speaking.
Pretty much. And flowing from that, it guaranteed justice for all citizens within this framework, regardless of their background. It laid the groundwork for a unified legal system.
Okay, so case 1 sets the stage, creates the unified community. What about cases 2 through 24? What kind of governmental architecture did they build on this foundation?
They started putting the meat on the bones. And what jumps out immediately, especially when you think about the context of the time, is the focus on checks on power.
Checks and balances. That sounds very modern.
It does, doesn't it? But the sources detail the immediate implementation of shura, consultation.
Tell us more about shura. Was it just like asking for opinions?
No, the source material frames it as much more than that. It was an enshrined constitutional mechanism. Governance had to be by council. Mandated. It's presented as the specific constitutional tool designed explicitly to prevent arbitrary rule, to stop a dictatorship from forming.
So how did it work in practice? Did the prophet have the final say?
Often, yes, the ultimate executive decision might rest with him, particularly in those early stages. But the requirement to seek out, to genuinely weigh, and to value counsel was non-negotiable.
Counsel from whom?
From designated representatives, key figures in the community, and often, depending on the issue, even from the general populace. It structurally limited the potential for unilateral power grabs.
Okay, that's a major check. But you mentioned another one that sounds even more radical for the time, an independent judiciary.
Yes, this is fundamental. The rulings made it incredibly clear. The judicial process could not and should not be swayed by political influence.
How did they ensure that, especially when the prophet himself was the leader?
Well, while he often acted as the final judge, he consistently established the principle of impartial judgment based on evidence.
Evidence, not status.
Exactly. The source highlights precedents where, if a regular person brought a complaint or a dispute, even if it was against the prophet himself, the case had to proceed based on the rules. Established evidence, documentation, witness testimony, not based on who the defendant was.
So real equality before the law, baked in from the start.
That was the standard set, the non-negotiable standard ensuring the legal system wasn't just a tool for the executive branch.
That structural limitation is powerful. And the cases also defined the executive authority itself. Didn't just limit it, but defined its role.
Yes, and this is crucial in a world where rulers were often seen as having absolute power by divine right or conquest.
Right.
This system constitutionally framed leadership differently. It defined it as service, a responsibility, a trust, not as a personal privilege.
Leadership as service.
That was the constitutional framing. And this limitation was reinforced by clearly defining the source of legislation.
Where did the laws come from?
The rulings established unequivocally that the Quran and the Sunnah, the prophets' traditions and practices, were the supreme law.
The ultimate source code, if you will.
You could put it that way. It meant any human-made rules, any administrative decisions, had to be consistent with this higher mandate.
So that provided stability and moral grounding.
Both. It ensured moral alignment because the core law was considered divinely sourced and immutable, and it provided legal stability because there was a clear ultimate reference point.
Okay, let's shift gears slightly to the economic side. You can't have a stable state without managing resources. Did these early foundational cases address that?
Absolutely. They went beyond just lawmaking. The source material details the establishment of the Beit al-Mal. We hear this term a lot.
Yeah, the Treasury.
But what was its constitutional function according to these rulings? It wasn't just a general pot for taxes.
Okay.
The rulings set it up as a specific public treasury, explicitly and constitutionally dedicated to social welfare.
Social welfare specifically.
Yes, funded primarily through things like the compulsory zakat contributions. This basically enshrined economic justice, the welfare safety net, as a constitutional duty of the state.
A duty, not just a policy choice.
Correct. It legally mandated that the state had to ensure the well-being and security of its most vulnerable citizens. And importantly, it ring-fenced those funds constitutionally to prevent them being diverted for, say, administrative overhead or political projects.
That's a powerful idea. And to make sure a system like that runs properly, you need good people. Did the rulings address appointments?
They did, critically. We see clear precedents set for merit-based appointments.
Meaning what exactly?
Meaning the source documents detail specific cases establishing a constitutional principle against nepotism or favoritism. No jobs for the boys, essentially.
Right.
Appointments to key roles, administrative, military, judicial, had to be based on competence, on trustworthiness, on proven skill, regardless of who you were related to or which tribe you came from.
Why was that seen as constitutionally important?
To guarantee the state actually functioned efficiently. Honestly, it set a remarkably high bar for public service ethics. Thinking about modern corporate governance or government hiring, it's still incredibly relevant.
Absolutely. So you have the structure, the welfare system, merit-based roles. How did they keep it honest? How did they ensure power didn't corrupt the system over time?
Through mandated transparency and accountability. This wasn't just a nice to have.
How did it work? Could people actually question the leaders?
Yes. The system established clear procedures for it. The Constitution allowed rulers, governors, administrators to be questioned publicly, constitutionally.
Question about what?
About their decisions, how they allocated resources from the Beit al-Mal, even about their personal conduct, if it impacted their role.
Seriously?
Yes. It wasn't just, a cultural norm. It was a legally enshrined procedure. The ruling authority was required to provide verifiable justifications for their action.
Which would discourage secrecy and abuse of power.
That was the clear intent. Make power answerable to the people it served.
Okay, before we wrap up part one, the outline mentions some forward-looking elements too. Things like succession guidance and federal balance. That sounds incredibly advanced for the 7th century.
It really does. On succession, while the ultimate model evolved after the Prophet's time, the principles for selecting leadership based on consultation and community acceptance were being established.
And federal balance, what did that look like?
Well, as the state began to expand beyond Medina into new regions, the rulings started to address how to manage that. How do you maintain consistent justice from the center?
Right.
While still allowing for local administrative decisions and respecting local needs.
The classic central versus regional tension.
Exactly. And the rulings established guidelines for delegating authority for the relationship between the central Beit al-Mal and local distribution, ensuring you had a unified legal state, but with operational flexibility in the provinces.
Fascinating. And one last point in this section. Knowledge as a constitutional duty. Education wasn't just encouraged, it was required by the state.
Yes, a core constitutional obligation according to these precedents.
What did that mean practically?
It meant that education, preserving texts, transmitting knowledge, especially legal and ethical knowledge, wasn't just an optional budget item. The state had a fundamental responsibility to educate its citizens.
Why was that seen as constitutionally vital?
To ensure the population was informed enough to participate effectively in shura, to understand their rights and duties, and to uphold the rule of law themselves. An informed citizenry was part of the system's design. Okay, so I laid the foundations, built the architecture on paper, so to speak. But, a constitution, any legal framework is really just theory until it gets tested.
Right, until it faces a real crisis.
Exactly. If the whole system just collapses under pressure, war, famine, economic attack, then what good was it?
It failed.
It failed. So, part 2 of the source material, covering cases 25 through 48, is all about that test. It shows how those fundamental laws we just discussed were actually applied or sometimes adapted during times of extreme stress.
So these cases demonstrate the Constitution working or being worked out in emergencies.
Precisely. Real-world application under duress.
This is where history becomes legal precedent. The outline mentions migrations, for instance. The early migration to Abyssinia, then the huge one, the Hijra to Medina.
Yeah.
How did these establish a constitutional right to seek refuge?
It wasn't just seen as an act of charity, like, oh, let's be nice to these newcomers. It was framed as institutionalized protection.
How so?
The rulings, especially those establishing the community in Medina with the Constitution, outlined the obligation of the Ansar, the hosts,
Uh-huh.
their constitutional obligation to not just welcome the Muhajirun, the refugees, but to fully integrate them, socially, economically, legally, sharing resources, creating bonds.
So it wasn't optional hospitality.
No. The source argues it set a profound precedent for humanitarian law. It defined the state's duty to protect those fleeing persecution and required the host community, the political body, to actually restructure itself to make that happen.
That's a very demanding standard.
It is. And then, almost immediately, the new state faced economic warfare. The outline points to the boycotts in Makkah before the migration. What precedents came from surviving that?
Right, that was intense pressure.
Extreme pressure. And the rulings that emerged from that period, and similar situations later, focused on the state's role in mobilizing resources.
Meaning?
They established the precedent that when facing economic attack or severe hardship, the state has an increased duty, a constitutional duty, to ensure essentials: food security, access to basic necessities for everyone,
How would it do that?
through specific legal frameworks. Things like communal resource sharing, preventing hoarding, stopping predatory price gouging during shortages. It reinforced the idea of the Bait al-Mal not just as a welfare fund, but as an emergency fund too.
Okay. Then, inevitably, came conflict. The Battle of Badr, the Battle of Uhud. These were life-and-death situations. What precedents emerged regarding command authority during battle?
Yeah, these cases analyzed rulings made right in the heat of conflict. They defined the scope and limits of military leadership.
Limits, even in battle.
Yes. Also, the decision-making process during battle, emphasizing consultation, shura, even then, where feasible. And, significantly, the constitutional requirement to conduct post-conflict analysis,
Learning from mistakes.
mandated learning from mistakes and losses. Ensuring accountability, yes, but without resorting to unfair blame or scapegoating. The key was that military strategy, however critical, had to remain subject to the supreme law, justice, fairness, ethical conduct.
And the Siege of Medina, the Battle of the Trench, Kondak? That sounds like a major test case for the Constitution itself. The trench strategy was huge.
It was the ultimate stress test for the Constitution of Medina, Case 1. The ruling required the unified effort of everyone in the political community, Muslims, allied tribes, everyone covered by the Constitution, to dig that defensive trench.
So it relied on that collective defense clause.
Absolutely. It relied heavily on those guarantees. The legal precedent set was crystal clear. During an existential threat, the Constitution mandates collective action. It requires resource contribution from all citizens. It showed the core law held firm, even when the city was surrounded, starving, and facing what looked like imminent destruction.
Okay, moving from defense to diplomacy under pressure. The Treaty of Hudaybiyah. This one's famous, often seen as a strategic masterpiece disguised as a setback.
Right. It often gets analyzed in strategic terms, but the source looks at it as a constitutional ruling.
How's it a ruling?
The decision to agree to the treaty terms, which seemed very disadvantageous to the Muslims at the time.
Yeah, like not being able to perform pilgrimage that year.
Exactly. That decision is framed as a constitutional ruling, prioritizing long-term strategic peace and legal stability over short-term military honor or immediate gains.
How did it ensure victory, as they say?
By stopping the fighting for a defined period, 10 years, I believe. The ruling created a crucial legal and social space. It allowed for dialogue, for interaction. The principles of Medina state justice, fairness, reliability could be demonstrated and communicated peacefully to surrounding tribes. It ultimately weakened the opposition through non-military means and set the stage for future stability. It was lawfare, in a sense.
Strategic peace through law. And the follow-up, the conquest of Makkah. That must have set huge precedents dealing with former enemies on such a scale.
Monumental precedents. Especially regarding reintegration. Makkah was the heart of the opposition, the source of persecution for years.
So revenge, retribution.
The ruling was the opposite. It mandated universal forgiveness instead of revenge, a general amnesty.
Wow, constitutionally mandated forgiveness.
Yes. This established a constitutional standard. Justice must serve the higher goals of political reconciliation and long-term stability, not just punishment. It was a legal act declaring former enemies are now peaceful, protected citizens. It defined citizenship through accepting the new legal order. through reconciliation, not through dwelling on past grievances.
That's incredibly powerful. And we also see rulings specifically on famine relief during crises.
Yes, reinforcing the Beit al-Mal principle. It wasn't just a peacetime policy. During famine, providing relief became an overriding constitutional responsibility of the state.
Non-negotiable.
Non-negotiable. The rulings detailed mechanisms for fair distribution, ensuring equitable access, making sure the preservation of life trumped almost all other administrative concerns during scarcity.
Okay, let's look inside the system during a crisis. The source highlights transparency and the right to know, cases 27 to 28. How did they balance openness with the need for secrecy in emergencies? That's a perennial problem.
It is. And the rulings attempted to define that balance constitutionally. They acknowledged, yes, the executive needs operational secrecy for security during conflict or crisis. That's practical.
Sure.
But, and this is the key, that need for secrecy did not override the foundational requirement for accountability back to the people, primarily through shura and established transparency mechanisms regarding resources.
So where was the line drawn?
The balance was struck by requiring disclosure on matters affecting collective welfare, financial integrity, things the public needed to know to ensure trust and fairness. Strategic or tactical information could be withheld, but only when demonstrably necessary for state security, and that justification itself could potentially be reviewed.
So national security couldn't just be a blanket excuse for total secrecy.
That's what the precedent aimed to prevent.
And related to that, institutional ethics, case 29. If a crisis exposed a flaw in the system, what happened?
The focus wasn't just on blaming an individual, though accountability existed. The ruling demanded an immediate constitutional review of the process or the institution that failed.
Fix the system, not just the person.
It's exactly fix the systemic vulnerability. This ensured the state apparatus itself learned and adapted, promoting long-term resilience rather than just cycling through personnel.
And finally, in this section, emergency adjudication, case 33. Justice can't just stop because there's a crisis.
No. The need for swift justice during emergencies was recognized. Things might need to move faster.
Right.
But the ruling strictly mandated that speed could never compromise fundamental fairness. Due process might be streamlined. Perhaps the normal rules of evidence gathering were harder under siege.
Right.
But the core principles couldn't be thrown out. Access to defense, impartiality, judgment based on available facts those had to hold. It showed an incredible commitment to the rule of law, even under the most extreme pressure.
Okay, so we've seen the foundations laid in part 1 and stress tested in part 2. Now, part 3 shifts focus, right? Down to the individual level.
Exactly. We move from the high-level state structures and crisis management to the actual experience of the ordinary citizen interacting with the justice system. Cases 49 through 70 really reveal the human face of this constitutional law.
How it was meant to protect the vulnerable and ensure fairness on the ground.
Precisely. And a truly just system has to start with access. So these rulings establish the right to legal aid.
Legal aid back then, how did that work?
It was a fundamental commitment laid down in the precedents. The principle was, no one, regardless of how poor they were, their tribal standing, their social position, nobody should be left defenseless in court.
So you couldn't be denied justice just because you couldn't afford representation or didn't know the process.
That was the constitutional principle. Economic status should not translate into judicial disadvantage. The system had an obligation to ensure everyone had assistance.
That principle of equal access, how was it supported in practice? The outline mentions procedural fairness, especially around evidence and documentation.
Yes, this was critical for ensuring judgments weren't arbitrary. The rulings demanded real precision from judges and administrators.
Precision in what?
Meticulous record-keeping was constitutionally required. Judgments had to be based on verifiable evidence documents, credible witness testimony, oaths where appropriate.
So, no ruling just based on hearsay or someone's memory.
That's what it aimed to prevent. It institutionalized a mechanism against arbitrary decisions. It set an administrative standard for keeping records, which ensures transparency, allows for review, and provides continuity, foundational for any system that relies on precedent.
Makes sense. And the process wasn't just about courts, right? It mentions alternative dispute resolution, ADR, being institutionalized.
That's right. The rulings recognize that a formal court battle isn't always the best way to achieve justice or resolve conflict.
So things like mediation.
Mediation, arbitration. These were constitutionally recognized as legitimate ways to settle disputes outside the formal court structure.
Why was that important?
It showed a more holistic view of justice. Justice wasn't just about punishment or declaring a winner and loser. It was often about healing relationships, finding mutually agreeable solutions, restoring harmony in the community. ADR was a formal part of that toolkit.
Okay, this leads naturally into the ethics of the people within the system. The source details rulings on the ethics of judges and lawyers. What kind of standards were set?
Exceptionally high standards, according to these precedents. The focus was heavily on preventing conflicts of interest, bias, and corruption.
Such as?
Specific rulings against judges taking gifts, for example. Strict warnings against showing any favoritism based on a person's status or wealth. Personal bias was to be rooted out.
What was the underlying principle?
That justice demanded unimpeachable integrity from those administering it. The moral character of judges and legal practitioners was seen as essential for the legitimacy of the entire system. If people couldn't trust the administrators, they wouldn't trust the law.
That makes sense. Now, something that feels very contemporary, I can see the focus on the rights of victims. What did that look like? Was it just about punishing the offender?
The source material suggests it was much broader than that. There was a strong emphasis on restorative justice.
Restorative, meaning?
Meaning the rulings emphasized that the ultimate function of the justice system should be focused on healing the harm done, healing the victim, healing the community, not solely on punishing the person who did wrong.
So how would that work?
Justice was seen as needing to restore what was lost, seeking compensation for the victim, daya in cases of physical harm, for instance, restitution property, and encouraging reconciliation where possible. It aimed to repair the damage and allow the victim to be made whole, while also considering how to reintegrate the offender, if appropriate, rather than just focusing on retribution.
A very different emphasis from purely punitive systems.
A distant philosophical underpinning, yes. And finally, for this part, with laws and rulings accumulating, how did the system maintain consistency in interpretation? How did they stop it becoming a confusing mess?
Good question. How do you manage precedent?
The rulings themselves provided the framework for this. It was clearly established that any new judicial ruling, any interpretation, any precedent being set, had to be consistent with the ultimate sources, the Quran and the Sunnah.
The supreme law we discussed earlier.
Exactly. That was the anchor. It ensured that even as the legal system grew and tackled new situations, it remained stable, coherent, and morally grounded.
So any new interpretation had to show its work, basically, show how it connected back to the fundamentals.
Precisely. It prevented legal drift, ensuring the expanding body of law didn't contradict its own foundations.
Okay, we're moving into the final sections, parts 4 and V, and part 4 seems crucial for the long-term survival of everything we've just discussed. Knowledge and institutional memory.
Absolutely critical. You can build the most brilliant legal system, the fairest constitution, but if the knowledge of it is lost, if the rulings are forgotten,
And it falls apart.
it ceases to function as a system based on law. So cases 71 through 90 address this directly. They frame knowledge as a collective trust.
A trust, meaning?
Meaning, it wasn't just the job of scholars. It was defined as a civic and constitutional responsibility for both the state and the people to safeguard this legal and intellectual heritage. Protecting the knowledge was protecting the state itself.
How did they do that institutionally? The outline mentions state archives and records. That sounds very organized for the 7th century.
It was remarkably forward-thinking. The rulings mandated mechanisms for preservation. This wasn't just about storing scrolls. It involved training specialized scribes, administrators who understood the importance of accurate documentation,
Accurate recording of decisions.
constitutional decisions, legal rulings, administrative precedents. The principle was clear. You can't have stable governance if yesterday's ruling on land rights or taxes or judicial matters is just lost, or only exists in one person's memory.
Right.
So it required structured archival practices to ensure the legal past could reliably inform the legal future. Institutional memory had to be built deliberately.
And this connects to transparency in documentation and scholarly transmission. It wasn't just about storing it, but passing it on reliably.
Exactly. The rulings emphasized the need for accurate, verifiable methods for transmitting legal knowledge across generations.
How do they ensure accuracy?
Through institutionalizing rigorous methods for vetting reports. What later developed into the sophisticated science of hadith criticism has its roots here. Knowledge transmission, especially legal knowledge, was treated with extreme care. It wasn't casual hearsay.
So establishing standards for legal scholarship.
Yes, demanding accuracy and verifiability, ensuring the constitutional continuity wasn't broken by mistakes or misinterpretations creeping in over time.
Okay, that covers preserving the legacy. Now, Part V, cases 91 to 120. This sounds like the wrap-up and analysis section of the whole study.
It is. It's the methodological and analytical capstone. This is where the authors of the source material step back and synthesize the findings from all 120 cases.
And what are the overarching core constitutional principles they identify? The main takeaways.
After analyzing all 120 rulings, they distill it down to, essentially, 4 non-negotiable pillars that run through the entire system.
Oh, sure.
First, justice. That's the ultimate aim, the guiding star for everything else. Second, consultation shura, the core mechanism for governance and decision-making. Third, equality, meaning the impartial application of law to absolutely everyone. And fourth, mercy, which acts as the ethical boundary, prioritizing human dignity, forgiveness, and reconciliation whenever possible.
Justice, consultation, equality, mercy.
Those are presented as the fundamental DNA of the state, recurring constantly across all the diverse rulings.
Now, for a study like this, relying on ancient texts, the methodology is everything. The outline mentions comparative analysis. How did the authors use that?
This is fascinating. They didn't just present these 7th century rulings in isolation.
Okay.
They systematically compared the principles, the structures, the functions found in these 120 cases with later legal developments around the world.
Like what?
For example, they might compare the principle of the ruler being subject to the law, or the requirements for due process, with elements that show up centuries later in, say, the Magna Carta, or Enlightenment ideas about governance.
What's the point of that comparison?
To demonstrate the foundational nature and arguably the historical precedence of some of these concepts within this specific prophetic legacy. It helps contextualize their significance not just within Islamic history, but within global legal history. It validates the claim that these were truly constitutional precedents.
And central to all of this, especially for you, the listener, who values critical thinking, is the verification of sources. How did they ensure these 1,400-year-old reports are actually reliable?
This is maybe the most crucial part of the whole study's credibility. The source material apparently dedicates enormous attention to the rigorous methods used for authentication of reports.
The critical thinking part.
Exactly. They detail the use of biographical analysis, ilm al-rihal, which meticulously vets every single person in the chain of transmission for a report, their memory, their character, their reliability.
Wow.
And they cross-reference reports, looking for textual consistency, contextual plausibility. Does this reported ruling fit with everything else known about the time and the prophet's established principles?
So it's a multi-layered verification process.
Extremely multi-layered and stringent. The goal is to ensure that the 120 cases they analyze are not just stories, but are as close as possible to historically reliable accounts of actual legal or constitutional decisions. That's what gives them weight for analysis today.
Okay, so let's bring it home. We've gone through this massive historical and legal structure. How does it connect back to you, the listener, dealing with 2024, 2025, and beyond? What's the future relevance, particularly for modern governance, economics, and, as you hinted at the start, the ethics of AI?
Well, the argument the source material builds towards is that these foundational principles are timeless, and they must be applied to our new challenges.
Give us an example with AI.
Okay, think about the constitutional demands we discussed. Merit-based appointments and transparency and accountability.
Right. No nepotism and power must explain itself.
Now, what if an AI system is making crucial decisions? Maybe deciding who gets hired for a job, or how public funds are allocated, or even judicial sentencing recommendations.
It's happening already.
Exactly. If that AI is using biased data, or if its decision-making process is completely opaque, a black box, then the constitutional principles derived from these rulings would demand action. We'd have to audit that algorithm as rigorously as we'd investigate a potentially corrupt human official. Is it fair? Is it transparent? Can it justify its decisions based on just principles?
Applying human accountability standards to the machine.
Precisely. Or take shura, consultation. The principle suggests that designing and deploying powerful AI shouldn't happen in a vacuum. It demands broad, diverse, consultative oversight to ensure the technology serves humanity ethically, grounded in justice and equality. The historical precedents set a very high ethical bar for how we should approach powerful new technologies. It's not just about what we can do, but what we should do based on these deep principles. Hashtag the 6. Outro and final thought.
Yeah.
So just to recap this whirlwind tour, we've looked at 120 foundational constitutional cases, broken down into 5 main parts.
Yeah, quite the journey.
From establishing that very first written constitution in Medina, setting up the Beit al-Mal for welfare,
Right.
through seeing how those laws actually functioned under the intense pressure of sieges and boycotts.
Just rest us.
Then zooming into the rights of individuals, the ethics demanded of judges, the focus on
That's
victims.
human element.
And finally, understanding the vital importance of preserving all this knowledge through state archives and rigorous scholarship. The sheer depth and comprehensive nature of this constitutional legacy, as presented in the source, is, well, it's quite breathtaking.
It really is. And I think the big takeaway for me, and hopefully for you listening, is this powerful vision of leadership as fundamentally being about service. And law, not just as a set of rules, but as a holistic, integrated system, an operating system for society, maybe.
That's a good way to put it.
Covering everything from the political architecture to crisis response to individual ethics, right down to institutional memory. And with justice always being the central measure, the ultimate benchmark for everything the state does.
And that holistic view, that demand for justice, really forces us to look critically at our own systems today, especially around economic justice and accountability.
Okay, give us a final thought to chew on then, something provocative based on all this.
All right, here's one for you to reflect on. Think about those two concepts we discussed. The Beit al-Mal, that public treasury constitutionally locked for social welfare.
Right.
And those strict rulings on merit-based appointments, demanding competence and integrity, fighting nepotism.
Got it.
Now, imagine if we took those principles seriously today. What if we constitutionally mandated, truly locked in, that a significant portion of public funds must go directly to collective social welfare, protected from political whims? And simultaneously, what if we constitutionally mandated that all significant public sector appointments, maybe even senior corporate roles that deeply affect the public good, must adhere strictly to proven merit and ethical standards, with mechanisms to prevent favoritism?
What would happen?
Well, that's the question for you. What profound, systemic, structural changes would that foundational legal perspective demand of our modern public spending, our political appointments, our corporate governance? Would our systems look radically different?
That is definitely something to think about. Are our modern systems truly built to serve the people first, or to serve power structures? A challenging question rooted in 1,400-year-old precedents.
Indeed.
This deep dive today has really only scratched the surface of these 120 rulings detailed in the source material. But the journey isn't over.
Not at all.
We plan to dedicate future deep dives to exploring these cases individually, 120 deep dives, one for each constitutional precedent, narrated, analyzed, and applied to our modern world.
It's an ambitious project, but the richness of the material demands it.
Absolutely. So stay with us for that. You won't want to miss unpacking this incredible legacy piece by piece.